Welcome back to Radio Entrepreneurs. Again, my name is Jeffrey Davis, and every week we like to invite into the studios Mark Furman to discuss litigation and business. You can't be in business and not understand or work through litigation or pre-litigation, make sure you don't have a problem. So welcome back, Mark.
Jeffrey, great to be with you.
Thank you very much. Mark, I see you have a huge, what a consultant would consider to be a huge brief in front of you.
Well, I want to talk about the deflategate. You know, everybody thinks it's over. The Pats are playing. They're playing well. Brady's playing well. But keep in mind, the NFL appealed from the decision of Judge Sherman finding in favor of Brady in overturning Roger Goodell's decision, suspending him for 4 games. And the appeal is scheduled, and it's going to be decided after the current season. And the question of whether Brady's going to be suspended for the first 4 games of the 2016 season is very much open to question. So sorry to remind Pats fans of this, but and the NFL has brought out further heavy artillery in terms of counsel, and they just filed their brief with the Second Circuit Court of Appeals that sits in New York.
But Brady gets to file a counter appeal, correct?
Which he has not done yet. He gets to file a counter brief, and there's going to be an argument this winter, and then a decision will come out in all likelihood after the Super Bowl. And but it'll decide what happens for the first 4 games next year.
Wow.
So
I have so many questions, but I'm going to wait already.
So, you know, the wonderful thing about the case, there's so many wonderful things about the case. There's even courses being taught on deflategate at University of New Hampshire this semester, because it's a wonderful educational thing in terms of the law, arbitration, the powers of an arbitrator, what's fair and what's unfair. So here's the introduction by the NFL in their new brief. Stripped of its celebrity, this case involves a straightforward exercise of authority expressly granted under the collective bargaining agreement and shielded from collateral attack by decades of precedent concerning labor arbitrations. Basically, what the NFL is saying...
We thought this was a monumental case.
Basically, what the NFL is saying is that Judge Sherman just substituted his judgment for that of the commissioner. And the whole idea of arbitration is that the courts don't decide the case. The arbitrator decides the case. And for whatever reason, over a period of decades, the NFL has successfully got the Players Association to agree that the commissioner could serve as an arbitrator of decisions, and he or she, it's a he, but can decide what is conduct detrimental to the integrity of or public confidence in the game of professional football. That comes right out of the collective bargaining agreement. And so what this case is about is Roger Goodell exercising that authority. But unlike any other arbitration case, I won't say any other, but 99.9% of other arbitrations, you have the arbitrator is an employee of one side.
Right.
And that is what makes this case so unique. Because if you just had a retired judge who had nothing to do with either party as the independent arbitrator, the decision as to Brady, had it been the same one, would have been affirmed, in my opinion. But the question is, what do you do with the fact that it really is not an independent arbitrator? He's an employee of one side.
Right.
And what do you do with the fact that the parties, both union and management, agreed to this system? Do you look at what he decides more strictly than you would in any other arbitration case? And while, so stated differently, what does a court do if it thinks it's more a kangaroo court than an independent arbitrator deciding the case on an impartial basis, as opposed to a view, not in the evidence, but a view in the public that this is revenge-gate because of criticism of the commissioner for the way he handled discipline in the past, particularly as to the Patriots with Spygate?
I actually believe that your segments are so important to this show. I consider it that it's sort of it's law school for entrepreneurs that you're bringing to us. And if somebody wants to know more about this case and other cases about entrepreneurship and the law, how would they find you?
I can be reached at 617-218-2025 or at mfurman, Furman, at tbhr-law.com.